Okay, Schwartzberg versus State is the next one up. While you all are making your way, I'm going to find my glasses.
I know him.
Okay, good morning, folks. Please proceed.
Council. May it please the court, Chief Judge, Your Honor, how are you? Robert Gershman and Douglas Lesser on behalf of Mr. Schwartzberg, the appellant herein and the defendant below. We raised 8 total points on appeal. The state confessed errors to sentencing on 1 point. Although we raised 2 sentencing points, they confessed errors to sentencing and agree with us that a resentencing should occur. So I'm not going to address either of the 2 sentencing charges, obviously, unless the court has any questions on the sentencing procedure used by His Honor in the lower court. In this case, count 1 was the rape, sexual battery, second-degree felony, 15-year max, which ended up to be a lesser first-degree misdemeanor battery. Count 2, as charged, third-degree felony, false imprisonment. And count 3, lesser first-degree misdemeanor, simple battery versus battery by strangulation. We feel that, and we sort of outlined in our brief in the order of what we thought was our strongest arguments, that was the court's denial of our request to play the entire 911 call pursuant to the rule of completeness. His Honor in the lower court denied our request as to 2 particular areas.
Let me ask you about that.
Yes, sir.
So there are essentially 2 redacted statements that are at issue, right?
Yes, sir.
Okay. How did those statements explain other statements that were made on the 911 call?
This was a self-defense, was the sole or equal to primary defense in this case. Those 2 separate statements, admittingly they total maybe 20, 22, 23 seconds into 2, that they were not necessarily responsive to the 911 operator. The first one was asking to spell the alleged victim's name. Defendant then talks about her being previously in a domestic physical dispute with her previous boyfriend. The next one was 911 operator saying, "Don't hang up." He responds by saying she broke her, in essence, she broke her nose, she broke his nose in that prior domestic.
Where were the 2 parties situated when the appellant's 911 call was being made?
Physically, he calls 911. They're inside of his home. Incident supposedly occurs within his bedroom, isolated into the bedroom. When the incident's over, she leaves, goes out the front door. During that time, he calls 911.
So she's already out the door.
The 911 call's a little lengthy, so it goes from house to outside of house. She comes back into house, and it continues for those in, out, in.
Can I ask you a question about the rule of completeness?
Yes, sir.
The rule of completeness is to prevent misleading, that you want it complete so that the jury doesn't have be misled into an improper view of the evidence. What specifically is misleading about those 2 redacted statements?
I don't think there's anything misleading about that. They're not responsive. Sorry, go ahead.
So under the rule of completeness, why does this judge, the trial judge, use discretion by not allowing 2 statements which are not misleading to the jury?
Yes, Your Honor. His Honor went through an analysis, clear from the transcript, on it is out of context type analysis. I framed it out of context. It's non-responsive, it has nothing to do with 911, self-serving, whatever other inadmissible type statements they may have been, which is not the correct standard to review under the rule of completeness under 90.108(1), where it is a fairness standard. And in this case, it should have been, 1, analyzed and argued under a fairness standard, not
You're
as...
saying fairness. Where is, I always thought it was a misleading standard. In other words, we're not to allow, by not allowing it misleads the jury into not knowing all the complete facts. Fairness, is more of a 403 perhaps analysis, but where is, so your argument is that we should adopt fairness as opposed to not be constrained by misleading.
And my authority for that is if just a plain reading of the statute to begin with, under 90.108 paren 1, not reading the whole paren 1, but just picking out the middle. An adverse party may require him or her at the time to introduce any other part or other writing or recorded statement that, in fairness, ought to be considered contemporaneously. So the statute talks about that fairness, and in this case, that fairness specifically went to relevancy, the heart of the defense, the nature of the assault, the state of mind of the defendant in a self-defense claim, and the rule of completeness, as the court knows from case law, trumps otherwise inadmissible evidence.
The Florida Supreme Court has said that the rule is known as completeness is to avoid the potential for creating misleading impressions by taking statements out of context.
Correct.
So that's how the Supreme Court's interpreting that statute.
But I think if there is an argument that it's taken out of context in this case, just going back to the trial itself, state introduces 911 tape with redacted 20 seconds. State relies upon it. State then, in their closing argument, fact specific here, in their closing argument invites the jury to listen to the 911 tape again during their deliberations. The jury, in fact, takes the state up on it, and the 911 tape is played during deliberations. So although a lesser comes back, the actual harm here is that instead of the defendant, who testified in this case, having to explain during our case in chief, they're even replayed for a second time an audio recording that doesn't allow the jury to hear what the defendant is contemporaneously and in fairness thinking at the time. That she beat up the prior boyfriend, she told me 5 minutes before, on and on about the rule of completeness. So they're left with half a story.
Let me ask you this, Mr. Christian.
Yes, sir.
I think you just answered it, but let me just make sure I understand your argument here with specificity. What portion of the redacted 911 call do you believe goes, as you put it, to the heart of your defense?
There are two areas, and it's written in there, so without necessarily quoting, but those two areas go to this alleged victim in this case being the aggressor and breaking the nose of a prior boyfriend that he knows then and there at the time of this alleged attack happened, therefore, state of mind for self-defense purposes, justifiable use of non-deadly force, what is the state of mind of the accused at the time? That specifically is what those statements go to.
What if, hypothetically, the appellant in this case had said, and while I'm on the phone 911, let me tell you, I know for a fact that she's beat up the last 11 of her boyfriends, and I'm going to be the 12th.
My answer is consistent, Judge. It's not about prior bad acts of the victim. It's not a sexual assault case where she's saying that she's promiscuous or whatnot. This is state of mind of the defendant in a core defense of self-defense.
And you're the judge, and you have something like 12 prior incidents. How do you balance that? And you use the word fairness. How do you balance that and what is relevant, what comes in based on your argument, and what is clearly over the line by then creating an unfair obstacle for, in this case, the prosecutor?
I think that, again, to some extent, discretion, as the court mentioned earlier, but you vet it out in court during the arguments, and in this case, the state said it was relevant. The court admitted it was relevant in the transcript, but redacted it because of the contextual analysis, which we say is under de novo review, inappropriate should have been the fairness analysis.
Did the appellant argue that during this 911 call he felt, at the time he was making the call, that he felt in danger, that she was going to come back? And
Yes, the defendant below stated same, he told the cop same, and he told the jury same when he testified. In fact, there's evidence that, for sure, at one point, not to be too graphic, she grabbed his genitalia and squeezed it, and he had to go for EMS help because of her actions versus her declining EMS.
Well, those are the actions that had taken place before his call, but
Yes.
I'm asking, during the call itself, is there any indication in the record that he felt during the call itself the shoe was going to come back?
Yes, there's almost what I would call like a chip turn play-by-play as to what she's doing, where she's going. She went to the neighbors. Neighbors aren't there. She's coming back. She's coming back into the house. I don't want her here. And then
Why didn't he lock the door? He was in fear.
he testified during the trial why he did not, and that was, without getting into his head, I would rely upon the record there. Thank you, judges. Oh, sorry. Did you have something else, Judge? Okay, sorry. Thank you.
Good morning. May it please the court. My name is Heidi Bettendorf, and I'm Assistant Attorney General representing the state of Florida. If I could just briefly address the sentencing issues that were raised. The state did concede on point 5 that a new sentencing proceeding was necessary pursuant to Norval. However, the relief requested by the defendant in his brief is for a resentencing before a new trial judge. The state does not feel that the record supports new sentencing before a new trial judge. There's nothing in the record that shows that the trial judge, which was Judge Kastrenakis, said anything or did anything that was prejudicial in particular to this defendant. He followed the state of the law at the time that it was at the time of sentencing. And as to the other issue where my opposing counsel alleges that he considered uncharged conduct, actually I'll rely on the brief, but the brief states that uncharged conduct was part of the criminal episode and was properly considered by the judge. So,
Can I just talk about before a new judge? I think Israel, Supreme Court, Muir and Till, as well as Gray, in all three cases, the courts remanded before a different judge. How do I distinguish those three cases from this case?
well, Your Honor, I would suggest that you rely on the record, which shows in this case that Judge Kastrenakis, especially in light of the Norval issue, was relying on the state of the law at the time. If you find that Judge Kastrenakis made...
No, I'm just following what the case law before us. So, are you saying, so if I delve into those three cases, there was issues specific about the judge's trial court's perceived impartiality in those cases, and then not in this one, and therefore that distinguishes this case from the other three? Is that what you're saying?
Your Honor, you're going to have to remember the factual background of the three cases, but I believe that Israel was about the certified copy of for purposes of PRR. Is that correct?
This is right.
Yeah, and I don't recall whether there was anything stated in that case that dealt with that defendant individually. I'm at a lot. I'm not as up to that case as you are.
No, I'm just trying to find out in terms of resentencing under a new judge, if there was anything about those three cases, why they all asked for a new judge as opposed to you coming and telling us it doesn't need to be a new judge.
Well, Your Honor, I don't think that every sentencing error requires new sentencing before a different trial judge.
That's true.
And so in this case, as I said, this was Judge Kastrenakis was relying on the state of the law before Norval was issued. So as to issue 5, we do agree that resentencing is required, but we don't agree that just because Judge Kastrenakis was relying on the state of the law at the time that shows that the defendant is entitled to a new judge. And as regards to the second sentencing issue, we don't believe that there was error in the sentencing, and so therefore, we don't believe that there should be a new judge issued based on what we've written in our brief as far as whether error occurred in considering the surrounding conduct for the offense. I'd like to briefly talk about issue number 2, which my opposing counsel did not discuss, but which I feel...
Could we get back to number 1?
Yes,
I
sir.
just like follow up on what questions I was asking panel counsel. If there's evidence that the appellant was still in contact with the alleged victim during the 911 call and based on his testimony was afraid of further violence, wouldn't those statements with respect to his perceptions of her record, wouldn't they be relevant?
Well, Your Honor, I would argue that they were non-responsive, as the trial judge discerned, and they were self-serving hearsay. and they were gratuitous responses to the information that the 911 operator was trying to elicit from him. Now, my opposing counsel argues that these statements should come in to support his claim of self-defense at trial. I would note that at no time did he ever argue down below that the exclusion of these statements made it so that he was required to testify in his own defense. These statements that he claims were pertinent to his claim of self-defense were elicited during the defendant's testimony, and therefore the state argues that the exclusion of the statements from the 911 tape are harmless because they did come out during the defendant's testimony.
I understand that we should use use of discretion.
Yes, that's correct. I feel compelled to, unless there are any further questions on issue number 1, I feel compelled to address issue number 2 solely because the answer brief that was filed in this case incorrectly answered this issue as it dealt with pre-custody, pre-Miranda statements that were made by the defendant, where the ruling down in the trial court below was specific that, I'm sorry, I have that backwards. The defendant argued on appeal that this was a post-custody, pre-Miranda statement. The ruling down below specifically was that this was a pre-custody, pre-Miranda statement. In support of the defendant's claim that this was a post-custody statement, he relies specifically on the testimony of Lieutenant Kantner, who was a paramedic who arrived at the scene. The testimony is clear from the record that Lieutenant Kantner was not the first fire rescue personnel to arrive on the scene, that Engine 46 arrived on the scene at 1:46. Lieutenant Kantner also specifically testified that the report that they were referring to at the trial did not accurately reflect what time Lieutenant Kantner arrived on the scene. And it was Lieutenant Kantner that provided testimony.
Did you argue this below, at least about the post-pre issue?
Well, he alleges in his brief that he argued this below. What happened below?
I'm asking, is there in the record?
There's nothing in the record where he argued post versus pre, Miranda, that it's a post versus pre-custody statement. But as I said, I felt compelled to address this issue because it was not properly addressed in the answer brief. If there are no further questions from this court as to any of the other issues, the state would rely on its answer brief and request that you please affirm the convictions and sentences in this case. Thank you very much.
Thank you.
May it please the court, counsel. 2 things. This is not, we would argue the rule of completeness is not an abuse of discretion when applying the wrong standard to the interpretation of authority. It is de novo. That is our argument. And as to the last point, post-arrest pre-Miranda was objected to in the lower court, in the transcript.
Do you have a cite for that?
Sure. The cites for that is transcript page 717 and 718 is where it begins. I object, court, on page 718, objection judged by me. We've addressed this previously, trial court. The court has ruled on this, and the ruling of the court is at this time that's admissible, overruled. Transcript 717, 718 in my reply brief on page 4. I'm over my time. Thank you very much.
Thank you very much, folks.